Yes, yes,
Yes.
yes, clear. What?
Okay, and confirm me if the screen is clearly visible to all of you. If you are facing inconvenience, do let me know.
Yeah, it's
Is it
visible
visible?
to every. Yes, yes.
Okay, so let's go ahead. So as you know, we can read the heading. The Supreme Court has put unmarried women on an equal footing in availing uh, abortion services. So the heading it clarifies that it is about abortion laws, and at a time when United States have altered, like they had the policy of allowing women to avail abortion. India took on a different stand. United Nations is a country which promotes liberal concept of liberalization across the globe, and the action recently taken was considered as conservative. But India, whereas, is now taking a firm stance, which is in contrary with, I mean, not contrary, which is in contrast, which is opposite to US. So we will discuss about this. That our Indian constitution is not like, I mean, our judges are able to take the decision on their own. They don't follow the trend. Okay, if they were following the trend like most other people do, then they would also have done the same thing. But here we see a different picture, and uh, we'll read about this throughout this article. So that is what this article describes. Okay, so scroll down a bit. Yeah. Okay, so now we will start reading. Okay, the most celebrated kind of court judgments are those that eliminate inheritance bias vested in a law or rule framed by the government. Okay, so here the this line describes that some inheritance. Inheritance means something that is coming from past, or something that is that you retain from someone. Okay, like from the past. Okay, so our country, as we all know, was a patriarchal society and more of a conservative style society back in lately. So we had our laws when they were being constituted, there also was some bias involved, and we'll see through as we move through this article, we'll see what were those, okay, biases. Okay, uh, so that is what telling that the okay, the line is saying that the most celebrated means the people who like to have such rules, people who cherish such laws, are those that eliminate means to remove. Okay, that removes biases. Okay, that remove biases. So this is the whole essence of the first line. Okay, so if there is no bias involved, of course people will find that justice is being delivered to them. So this is the whole essence of first line. We'll move to the next line. The Supreme Court moved last week to set right a rule that was manifestly arbitrary and violative of women's right to bodily dignity, fits right into the concept of justice that is free and without prejudice or favor to any person or group of people. So again, the essence, will go through the essence of this line. So the Supreme Court's move last week, which means the decision which the Supreme Court proposed last week, to set right. To set right means to 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 make something correct. Okay, which was previously not right. So now to set right. So they have corrected it. A rule. What they have corrected? A rule. They have corrected a rule that was manifestly arbitrary. Uh, Arbitrary means in okay. You like arbitrary number means a random thing. Okay, so randomly chosen, like arbitrary number. Just think of an arbitrary number. That means any number that comes to your hand. So it was random, and justice should not be random. Like it should not be dependent on the judges. Like if the judge, it should not depend on the mood of justice. Like if they want to give someone a law for abortion, they should, and if they don't, they should not. It should be equal to some. There should be some ground, and this should be equal ground, so that everyone feel that they have been dealt in a fair way. Okay, so again here it is saying that that was manifestly arbitrary and violative of women's right to bodily dignity. Bodily dignity means if you have a body, so it should be your choice what you do with this body. Let's say that I have I have face, perhaps I don't like my face, so it's my choice to have a plastic surgery or whatever. Okay, no one else can dictate it, even though the country, let's say that I am not fair looking individual. okay, and now I'm going to have a plastic surgery to make myself look more fair. And if someone question that, no, this is racist, you are, why are you making yourself fair? No, it is my body, so it should be my choice, okay. You cannot question about racism or something in that picture. So this is called bodily dignity, okay, that your body should it should be your choice, okay. And violate means against. Violate, you all know, violate means to go against. So it is against the, like, will of a person, or it violates the bodily dignity. Okay, moving on to the next line. Uh, what is that? Bodily dignity fits right into the corner of justice. Okay, so this change that they have made, it fits right into the corner of justice, which means now it is more fair, okay, and without prejudice of favor to any person or group of people. So now it is more fair, and it does not favor any particular side, okay. It is not arbitrary anymore. It, like, the judges rule is now less. It's like fair ground for everyone. And why is it fair, we will come to know as we proceed forward. So we'll move to the next paragraph. Scroll down a bit. Yeah, so now we'll read this paragraph. Earlier means before. The apex court in its wisdom, apex court in its decision. Wisdom means with their, like, apex court, they are considered as more experienced judges. So again, we can say that wisdom, we can replace that wisdom with experience. Okay, so the apex court in having more experience, the judges having more experience. Okay, facilitated the abortion of a young woman whose partner parted ways after after realizing she was pregnant. So earlier, the apex court, in its wisdom, in its what do I say, in its experience, help. I mean, facilitate. Facilitate means allowed. Okay, to allow the abortion of young women, young unmarried women. Okay, unmarried means the girl who is not married. If it is married and then they want abortion, the court allowed them. But when a girl was not married, they were not allowed after 20 weeks. So before 20 weeks they were allowing it, okay. But if she is pregnant for more than 20 weeks, okay, then they were denying it, okay. So you cannot have abortion anymore. But on the same ground, at the same time, others women who are married, they can have abortion even after this period of 20 weeks. And this was a bit unfair. Even it, like, even I have my own body, okay, and my partner have left me. Let's say that he came to know that I am pregnant, and now he's saying that I won't marry you. Now she had trusted him. Now he betrayed her. So instead of punishing the culprit, which is the partner, male partner here, why to punish the women who don't want to? How can she carry the, like, without any support of the male partner? How can she carry his child? Okay, it should be either the parenting should be from mutual. If one cannot take the burden alone. So if she decides not to deliver this child, then it should be her choice, okay. But the court will deny, like, after and up to 20 weeks it is fine, but if it has crossed that line, no, you will not be allowed. And if you will not be allowed, but if you have not, if you are a married woman, and no matter what, like, even when you have crossed 20 weeks, you are allowed. So this was sounding a bit unfair, okay. So this was the essence of the first sentence, and then we will move to the next one. uh, had the court rested then, okay, this was the earlier decision. As the sentence have started with earlier, this was happening before. But now, has the court rested then, which means if the court had stopped there and they would not have changed the law, if they could have rested there, rested means to stop right there, then what could have happened? um, let's see. Had the court rested, then it might have meant relief for one woman, which means it might have meant relief for one woman who is married, okay, uh, who had to go through all the way to the top court of the land in order to access that seven other categories of women would have been able to do without legal hassle. Acha, here there is a word, hassle. Hassle means you can say annoyance, okay, annoyance, or what do I say? Uh, uh, Annoyance or irritation, okay. Like, you have to go through all these legal troubles. So you can even see it in the sense of trouble. So for a woman who is unmarried, she will have to go through all the way to the top court, and that too, she is not supported by her partners, okay, partner, and she have to go to the Supreme Court just to get the permission granted for having an abortion. And for a woman who have the support of family and as well as his husband, she can avail this without even consulting any legal department, without getting into legal trouble. She can just say the doctor, I want abortion, and she would have got it. And again, this sounds a bit unfair, okay, to a young woman, isn't it? So now we'll move to the next sentence, next paragraph. So scroll down, please. Yeah. Without the judgment, while the judgment could have been cited in the support of other women in the similar situation, the law retained its flaw, and other would still have had to take the long legal route and wait upon the discretion of individual judges. Now, again, as I pointed out previously, it was arbitrary. Okay, so now see why it is arbitrary. So while the judgment could have been cited in support of other women in similar situations, now see who are these other women. Okay, so these other women are categories of women. So the court classifies women into 7 categories or perhaps 8 categories. I'm not aware exactly. And what are these categories? How are these category classified? So I'll tell you the classification. So one category is again unmarried women who was who have willingly had intimacy with her partner, okay, and she got pregnant, and now she is trying to avail abortion. One category is a married woman that we have already discussed, but another category is of a rape victim. Okay, so there are seven other categories as well, but I am aware of these three. So I just try to explain you what are these other categories of women. Okay, so there are many grounds on which the Supreme Court uh, classify a pregnant woman. Okay, like one other could be one other possibility could be of a medical condition. Like let's say that the woman can die if she go through if she don't abort a child, she might even die. So there are many medical troubles. Okay, so this is called medical complications. So in case of medical complications as well, they need to avail what we call abortion, right? So these are the different classification of women. Okay, so now here it is saying that while the judgment could have been cited in support of other women. So what are other women? Those who are not unmarried, those who are sorry, those who are married, okay, and or either a rape victim or either a medical uh, complication. These were allowed, but not the one who is unmarried and had is pregnant. Okay, so yeah, here other woman is used in that sense. So it shows that the law retained its flaws, which means the law retained its flaws. Here it is clearly saying the law retained its flaws, which means the previous system or previous adoption of the law of pregnancy abortion was of flaw. Okay, it contained some flaw which was pertain to some mistakes. Anyway, so moving on, and other would have still other would still have had to take long legal route. Others now here others means unmarried unmarried woman who is pregnant. Now they have to, I mean, young girl who just had who had a boyfriend, but again when the boyfriend realized that she is pregnant, he just left her. Okay, so in such cases these women were not, they had to go to Supreme Court, okay, in order to avail abortion, and which was a very difficult thing. Now it was up to the judge. If the judge grants you to avail abortion, you can grant, you are allowed to have abortion. If the judge do not grant you, then you'll have to, carry that child, bring, deliver the child, and you'll have to uh, brought it up. So yeah, this was the thing. So again, see the thing here. The judge is the one who is deciding whether the abortion will take place or not. And although it should be her choice because it is her body, whether let's say I'm suffering from a sickness or something, I want to have a surgery, so it should be my choice, not the judge, that whether you should or should not have this surgery. If I don't want my hand, I want just to cut my thumb, it should be my choice. I may sound insensitive here, but I'm just telling you, your body is entirely your choice. Moving on. Okay, so let's scroll down a bit further. Yeah, utilizing the full expansive reach of its power, the Supreme Court had decided to correct the anomaly. So utilizing the full expansive reach of power, which means Supreme Court used its authority. Okay, of course, it being the topmost court, have more authority than high courts or district level courts. So it utilize this authority over other courts to come to a decision and to remove the to correct the anomaly. Okay, anomaly is a word which means partiality. Okay, partiality or yeah, you can take it in the sense of partiality, which means like the same law will treat you differently if you are an if you are a young woman, and if you are a married woman who is again older, then it will treat you differently. Okay, so this was partiality being done. So now it has corrected that partiality, utilizing its power. It has corrected that partiality. Now moving on, and these were the bench, the judges who made this remarkable decision were a bench compromising justices comprising sorry a bench comprising means composed of. Okay, to compose, to be formed of a bench here. Bench does not mean the literal bench that we see in our school. Bench here means a committee of judges. Okay, in legal terms bench means committee of judges. So dy Chandrachud and jb Pardiwala. So these were the two judges who made this remarkable judgment. Okay, are considering pronouncing a judgment which would make access to medical abortion a level playing ground. So after this decision being made, this will now see this term level playing field. What is the meaning of level playing field? It means to play fair. Okay, to make it fair. Level playing means rules to be equal. Okay, like to make it equal, to make it fair to everyone. So yeah, this judgment. The basic essence is using its power, the Supreme Court of India altered the previous rule and made some amendment and changed it and made it more fair. Okay, that's the whole essence. Moving on. Okay, so scroll down a bit. Yeah. Now, see, abortion law. In legal terms, it is addressed as the Medical Termination of Pregnancy Act. Okay, abortion is a verb that is adopted in general collocation, but in legal terms, uh, we have named it in this form. Okay, this article was written in this form: the medical termination of pregnancy. Termination of pregnancy can otherwise be addressed as abortion. Okay, so do not get confused with this different addressing of the context. Okay, and this act came into picture in 1971. Okay, and its rule. Um, okay, and its rule 2003 prohibited unmarried women who are between 20 to okay. So okay, I'll read the whole paragraph in a stretch. So the Medical Termination Pregnancy Act 1971 and its rules 2003 prohibited unmarried women who are between 20 weeks and 24 weeks pregnant to terminate the pregnancy. So now you see here that prohibited means denied or not allow. Okay, so this law did not allow women who were unmarried and who were pregnant beyond 20 weeks. Okay, beyond 20 weeks. Okay, so if they were pregnant beyond 20 weeks, then they were not granted abortion. Okay, as per the law, this law prohibited them, means denied them to avail abortion. Okay, moving on. The court's argument pierced at the heart of the inequity in the law. Inequity, again, it's a term which again means impartiality. So the court's argument pierce means pierce have little meaning of to tear something. Okay, to tear. Okay, here, but the here it is used in a metaphorical sense, which means to remove or to hit hard. Okay, to remove or hit hard, something like that. So the court judgment hit hard. Pierce the heart. Okay, pierce the heart. Okay, pierce the heart. You can take it as a phrase. So PS, you see, PS means to stab a knife. Okay, PS means you can pierce something. You can stab something. PS means to stab the heart. When you stab the heart, the person dies. Okay, so you can easily interpret. Sometimes you don't have to know the meaning of phrases. You can interpret them in your own understanding. Okay, so pierce the heart. When you pierce the heart, that means that person is dead. In this term, it is used as a metaphor, or figuratively. It is used figuratively, which means that the rule is dead now. Okay, so prohibiting the unmarried woman this rule that was existing before is not now not not you can say not into power anymore. Okay. Okay. 20 uh, pregnant the court's argument pierced the heart of inequity in the law. So the court argument removed the impartiality. If a sorry, remove the partiality, not impartiality, remove the partiality. Okay. If a married woman had access to abortion facilities during the same period, then why should, now again the article here raises a question that if a married woman with the same period of 20 to 24 weeks is can be allowed for pregnancy, why can't why should an unmarried woman not? I mean, it sounds a bit unfair, right? They both are human beings, and still why to have different rules for these two individuals. They both are women. They both should be treated fairly. So again, moving on to the next. So this raises a question, and we'll get the answer in the next paragraph. Okay. So just scroll down. Yeah. Exhorting. Yeah. Exhorting the government to have forward-looking interpretation of the law of law. The bench pointed out the rules mention partner and not husband. Okay, exhorting the government to have a forward-looking interpretation of the law. So again, the forward-looking interpretation of the law. Forward-looking means a more advanced. You can take it, you can understand in the sense of a more advanced, modern. Okay, forward-looking means a modern way. Okay, the forward-looking interpretation of the law. Forward-looking, okay, modern-looking interpretation means like law, the constitution, our constitution was made again. This you see that this law was introduced in 1971, but right now we are living in 2022, so we need to update our law as well. So this law should be modernized, and that's what the essence here is. Okay, so the bench pointed out the rules mentioned partner and not husband. So previously in the same law which was constituted in 1971, they had used the term partner. Sorry, they had used the term husband, and this term husband was creating all the trouble for unmarried women because the partners that they had, they had boyfriends, not husbands, right? So that's why now, because of this term husband, they were not being allowed to avail abortion. So now they have changed this word, and now they have used the word partner instead. Now a boyfriend can be a partner, even a husband can be a partner. So now even the girls who had boyfriends and whose boyfriend might have left them, they can also avail abortion. Okay, so that's the essence of this paragraph. Moving on to the next one. Yeah, scroll down. Yeah. Okay. If the Supreme Court was feted for taking a liberal views, again feted here means to honor. Okay, Supreme Court can be honored or praised for taking a liberal view of the law. Liberal view means one, liberal means a more open, not conservative. Okay, not old-minded, not ancient concept. Okay, not theological. It's more practical and more, what do I say, uh, more liberal in the sense more open mind. Okay, so yeah, if the Supreme Court was feted, honored, if the Supreme Court was honored for taking a liberal view of the law, its act of pushing the envelope further to set right the existing anomalies. Again, we have seen the use of the word anomalies. We know the meaning of anomalies. I have just described above. Anomalies means partiality or discrimination. Okay, treating two peoples differently. So this is anomaly. And I will also tell you another word which is the um, which is the antonym of this word. So that is analogous. So analogous means similar. Okay, and anomalous means which is opposite. Okay, anomalous means opposite to that. So here it means opposite means different, partial. Okay, so if the Supreme Court was feted for taking liberal views of the law, its act of pushing the envelope further to set right existing anomalies in the law is to be celebrated in full measure. So here the author is trying to praise this judgment, saying that if the Supreme Court is honored, then its judgment should also be celebrated in full measure. So we should have we should be happy about it. We should be open about it, and we should be cheerful about it. That's what he's trying to point out here. Okay, at a time when United is, and particularly because again, as I was started with the discussion in the very beginning, and this is more important and more crucial because at a time when United States, which happens to be a country which promotes liberalism, okay, which is considered as the most liberal country. So at a time when United States, the most liberal country, uh, Supreme Court, yani the Supreme Court of United States, recently rule recent in its recent ruling overturn overturning Roe versus Wade has drawn that nation back several decades on the abortion question. India's apex court movement stands out in the sharp contrast. So I will tell you the essence of this. It is basically saying that in United States recently they have said that abortion won't be allowed. Okay, their Supreme Court is now, their Supreme Court is now taking decision which was ancient, okay, which sounds a bit old fashioned, and now and at a time of this, like when United States, and which is the most modern country of the world, their Supreme Court judges are making old fashioned decisions. Here in India we see that our judges are making more modern or more practical, more liberal judgment. So this is praisable. This is, since India was not known for being a liberal country, it was a more of a conservative society. So it takes really to come out of this bias. Since we are also we have also have been born in this country. So when you were a child, as a judge, everyone have had uh, a childhood. So when you are grown up in a country which had conservative biases involved, and which had a patriarchal mindset, you are also somewhere a bit influenced by this. But these judges really have to come out of this bias and influences, and they have to come to a neutral decision. So this is something which is praisable. This is the essence which I understand from this paragraph. Okay, coming to the next one. Uh, uh, can you scroll down a bit? Yeah, it is surest example the court's willingness to be modern and progressive. Again, as I pointed out the word modern already before. So modern and progressive. So again, this clearly is an evidence that our court is moving in a progressive direction and in an area of modernization. So the court is being more advanced and looking for more practical liberal views. Okay, in order to remove, and why are they are doing so? Why are they being liberal in its decisions? In order to remove antediluvian. The word antediluvian means biblical or something which relates to the time of Jesus Christ. Okay, when biblical means Bible, the word biblical means Bible. In other words, it's a very old word. So antediluvian means ancient, you can say, to understand it. But otherwise, it has the literal meaning of the time at the time of Bible, at the time of Jesus Christ or uh, uh, time. So again, basically, it want to say that our court is not not making decisions which are again old fashioned. They are they are using modern, they are coming to modern decisions. Okay, um, anti-dividend inconsistent existing in the law. It it is also in full spirit of the article 14 to the constitution that guarantees to all person equality before the law and equal protection of the law.
Sorry for the interruption. Sorry for the interruption. Anurag, can you please explain what is the meaning of anomalies?
Anomalies, partiality or differentiation. Okay, so it means to differentiate, partiality, something like that.
No. Anomaly means something that is different from what is normal or usual. That is not partiality.
Right now here, I think, okay, for me, I to understand things, I relate with the things that I know already. And again, for you, okay, right now we will not get into vocabulary. I will come to you at the end. Right now, let this section be progress
No,
in
no, no. Actually, partiality is different from the word anomaly. That's why I interrupted. You can continue now.
Okay, fine, thanks for that information, I appreciate it. Moving on. So again, so it is also in full spirit of the article 14. So now here they have brought article 14 into the picture. Article 14 means article 14 is a law which grants equality. Okay, equality of each individual. So this is a law which grants equality. Now it was against equality of uh, women, because a young woman was being treated differently, or, or if I be more precise, unmarried women was being treated more differently than a married woman. So again, to remove this partiality, we had this decision was made, and this is a serious example of court willingness that it is heading in a progressive direction. So that's all this. That's all the essence which is involved in this paragraph. So moving on, the next one. Okay. The law cannot cherry pick beneficiaries. Okay. So here the word there is this phrase I would say cherry pick. Cherry pick means to pick yourself, like to cherry pick means what suits you. Like maybe it's your like by your choice. Like if I decide to pick someone, like it is called cherry picking. Like to my favor. Like if I want to. Okay, let's say that there are many things items in front of you. Okay, and cherry picking means like if you like mango, you are picking mango, but you are not caring about others who might be also willing to have mango. So again, this sounds a bit biased. Like it's up to the judges to cherry pick who should be allowed for abortion, who should not be. Okay, so again, the law cannot cherry pick beneficiaries. Again, it means the interpretation would be that the law could not that I mean law should be unfair, right? It should not be picky. Like it will only pick uh, unmarried women. It will only pick married women for abortion. It will only pick those who are rape victims for abortion. No, it cannot differentiate like that. Law should be fair to everyone. So that's the first line essence. And if there is to be any justice at all, again, if we were to promote justice, the essence here is that if we were to promote justice, we should not cherry pick anyone. Like this decision will go into this favor, and this decision will not go into his favor. It should not. This is against the principle of justice. Okay, all the antiquated, and again antiquated means pertaining to old time, pertaining to old era. Okay, so the antiquated principle on which the old acts were built cannot continue to frustrate young women. So again, based on this old woman, based on this old act, which was again introduced in 1971, we cannot continue to frustrate young women. So that's the essence. I think it is very clear. I need not explain it any further. Who claims autonomy of their own body? Again, here look at this line. Who claims autonomy of their own body? Which means if it is my body, so it should be my choice. Okay, having autonomy means authority. Having the authority. So if it is my body, it should be my choice. If I want to undergo a surgery, it should be my choice. If I don't want to undergo a surgery, it should be my choice because it's my body, and the court judges should not decide. So again, this is the whole essence in this paragraph. Okay, moving on next. So scroll down a bit. So now we have completed the whole discussion, and I would like to hear from you. So if you have any doubts, please raise. Okay, if since no one have responded to doubts, so I would take it as no one has any queries. So again, tune of the editorial. What was I would like to ask you guys first? What is the tune of the editorial? So anyone who would like to voluntarily tell what was the tune of this editorial?
Yeah, it's analytical tone because the author is analyzing a law.
Okay, anyone else?
Yes.
Anyone else?
Basically, yes, yes, I'm here. So basically, the article talks about a previous law, which was actually hindering the progress of the bodily integrity of women, and right now Supreme Court has come up with a new judgment, which actually protects their Article 14, wherein their bodily integrity has been respected. So in that sense, we can say that it's an analysis of the previous law, and the flaws with respect to that particular law has been pointed out, and they have actually given the facts related to the Supreme Court judgment. Basically, it's all about the Supreme Court analysis of judgment, which has been analyzed here, and then the points of the Supreme Court judges has also been given. So it's a I would choose it as an analytical one or a factual one based on a judgment, which is forward looking.
Okay, so if there is anyone who would still like to say what they think about the tune of this editorial, what was the tune? Anyone who would like to volunteer? Okay, so I'll take since no one have responded, I will take as no, they. Okay, anyway, I will explain what is the tune. So, as per my understanding, I think that at some part we have seen that the editor have clearly mentioned that we should celebrate this law. Okay, these changes. So, at some point they have appreciated it. So, this comes into the category of laudation. Okay, laudatory tune. Now, at some point they have also analyzed, which was suggested by other members, other. So yeah, so at some point they have analyzed the law. So they have analyzed. They have also been laudatory at points, and they have also presented facts. So in my opinion, I think it was a mix of laudatory and analytical tune. So it was a mix. I think I would call it a mix of both. Uh, since laudatory is not usually seen because author maintain the neutrality, they never, they rarely praise something. So I would give it, and so I would rather call it, I would rather call it laudatory because this is something that is not usually seen. And if someone is purposefully praising something, which again authors avoid, and they are again here they don't intend to avoid. That means they are trying to praise this. That they are trying to praise this judgment, and for me it is laudatory. So that's all we have. So can you scroll down a bit? Do we have something more here?
Are you talking about newspaper editorials?
Yeah, I think we had this session of editorial discussion, and we have already concluded it. Anyway, so and very well, Altruist concluded very well the summary. So have you joined right now, Jagjit Baba?
Yes, I have joined right now.
So this session will be uploaded on YouTube. So as per the time of your convenience, you can watch this video. Okay. And moreover,
Okay.
for your for a descriptive understanding, you can go through the YouTube video. For your uh, you know for time efficiency, I will ask Altruist to again summarize it again once for all the other members. So by the way, before you proceed, Altruist, I would like to ask others. Anyone else who would like to summarize it? Who will tell what is the summary for it? None. So okay, Altruist, please summarize it.
So basically, the intent of this editorial is related to a recent Supreme Court judgment, which is actually progressive. So we had this Medical Termination of Pregnancy Act, which was enacted in 1971, and we had these rules which has been enacted based on that act, which was provided in 2003. So these rules states that a married woman, or the timeline for which an abortion can be done for an unmarried lady was 20 weeks. And there are other exceptions wherein when can a lady abort after or post 20 weeks. So we can do abortion till 24 weeks. There are certain exceptions for rape or survivors of rape or other married women who have issues with that. So that's what the article says about here. The Supreme Court has found out a point that after 20 weeks, even an unmarried woman can actually abort, because the law states that about a person, if a lady is married to not married, if a lady is in relation to a person, so it states that it doesn't involve that she should be married. So this was the case, like a lady was actually having an affair with a person, and she got to know that she is pregnant after 20 weeks. She was already knowing it, but after 20 weeks, she had an issue with her partner, so they were unmarried. So that lady went to the Delhi first. That lady went to Delhi High Court. So the Delhi High Court actually dismissed her petition, and after that, she went to Supreme Court. Supreme Court upheld like her justification, saying that yes, she can abort the lady because it was actually affecting her mental health. So this is the basis of this judgment, saying that even though the married woman could do it after 20 weeks, why couldn't unmarried woman do that? So this is why it is in contrast or anomaly with respect to the US judgment recently, which was passed by the Supreme Court of US, stating it actually banned the abortion law. So that's why Indian Supreme Court is more progressive with respect to the abortion laws of providing the bodily integrity or the equality. Article 14, equality before law and equal protection of law, has been provided by our Supreme Court in this regard. So this is why it says that this is actually progressive in nature.
Yeah, so thank you very much for that summary. And with that, I think the session is concluded. although we have concluded 3 minutes earlier than the scheduled time, which was 12 o'clock. So anyone, meanwhile, since we have 3 more minutes, anyone who have any question to raise, please go ahead.
No, no questions. You explained the article very perfectly, I would say. Thank you.
Thanks. Okay, so guys, I think we can consider this session concluded. I enjoyed. Thanks for participating, all of you. Your attendance matters a lot, and I really felt honored to host this session before you all. Keep joining this session, and yeah, your participation matter a lot. It really encourages us to keep conducting such sessions. So keep participating like this and keep showing your attendance, and we appreciate your support to us. Thank you very much. So it's time for me to now depart. Signing off. Yeah.